Session, please.
Still morning. Welcome back. As you folks can see, we have reconstituted the panel. My colleague, Justice Hand, now on my right. As Justice Diffkoff mentioned this morning, I'm quite certain that Judge Wolohojian would have been very comfortable being here, but she had other things that she has to do. So, hence the last-minute changes to the panel. The next case, I believe, is impounded. Whether it is or it isn't, we're not going to use names. We're going to use mother, father, child. And is it Ms. Packlin? You may proceed.
Members of the panel, may it please the court, Nicole Paquin on behalf of the appellant mother who is present in the courtroom today and who is asking you to vacate the judge's finding of unfitness and termination of her parental rights and to remand this matter for further proceedings before a different judge. In this case, the trial judge really relied on four legs to find mother unfit, but each fails under scrutiny as each is either clearly erroneous or relies upon an extremely distorted, untenable version of the facts. First, the judge made findings about mother's mental health. The judge discredited mother's engagement in therapy based solely on the licensure status of her therapist, which is clearly erroneous and cast doubt on all of the findings regarding mother's ongoing mental health concerns.
What finding do you rely on to say that his discrediting was based solely on that?
So he prefaces his findings on addendum page 50, which does not have a finding number, which states that she does not have a license, and so it's
No, but where exactly are you relying on that? That's why I'm struggling, because I did review the findings, and I did not take away from those findings the conclusion that the judge's discrediting, if you will, or non-reliance on therapy came because the therapist was unlicensed.
So in addendum page 49, also record appendix volume 2, page 214, and it discussed that Ms. Hill does not qualify as a licensed therapist within the Commonwealth. As such, this court provides little weight to Ms. Hill's testimony aside from some facts mother reported to Ms. Hill. And then there's a footnote which appears on the following page, record appendix 215, which discusses Ms. Hill's qualifications. And then
so that's very helpful. I don't know how I quite missed that, but what's the next thing you want me to look at?
So there are several findings. There are, but I think most importantly are conclusions of law 11, 13, 32 subsection 4, 32 subsection 13, and 33. And in 23, conclusion of law 23, I'm sorry, that is not, that's, and 32, sorry. In conclusion of law 32, subsection 4, the judge specifically found that the licensure status was more concerning, even more concerning than mother's attendance or engagement with the therapy.
But could I go back to that point of engagement, Attorney Paquin? If I heard you correctly, your contention was that the judge found, based on Ms. Hill's lack of qualifications in the judge's view, that the mother was not engaged in therapy. I'm not sure that that's correct. It wasn't a matter of the mother's engagement. It was a matter of Ms. Hill's perception of the mother's benefiting from the services. Am I right about that?
So I think that's what the judge I want to make sure that I understand your question.
Sure.
So I think what you're asking is, did the judge find Ms. Hill able to address mother's mental health concerns? Is that?
The question I was asking initially was, your point, if I understand correctly, is not that the mother was not participating in services with Ms. Hill, but that Ms. Hill's opinion was of little weight to the judge because of the judge's assessment of Ms. Hill's lack of qualifications. Am I correct about that?
It's twofold, because the judge gave little weight to Hill's testimony, but the judge also found that mother had not addressed the mental health concerns with a qualified licensed therapist. That's conclusion of law 32, subsection 8. And so the judge's findings indicate that he did not credit mother's actual engagement with the therapist. Mother was required under
therapist, correct?
well, mother was not required to see a licensed therapist.
Even if that's the case, but that's not factually erroneous that mother was not engaged, as far as Ms. Hill was concerned, with a licensed therapist. Ms. Hill testified she wasn't a licensed therapist.
She was not licensed.
Correct.
But the judge faulted her for not seeing a qualified licensed therapist and choosing to engage in therapy with an unlicensed therapist. There was no requirement.
I see that in 8, but I don't see that elsewhere where she's faulted for that. Can I ask you, what is it that was excluded? What opinion was excluded that you think was important to mother's case?
So to clarify, Ms. Hill was never offered, she was never proffered as an expert. I realize that that is how the child has argued, that this was, and that she should have, that the mother was arguing that Ms. Hill should have been qualified as an expert. That's not the issue. Ms. Hill was never proffered as an expert. Ms. Hill was offered and called to testify based on her own engagement with mother. So the issue is whether the judge was correct in giving such little weight to Ms. Hill's testimony and in discrediting mother's engagement with this provider for 2 years when there was no requirement that mother see a licensed therapist. This is how individuals become licensed therapists.
I didn't get an answer to my question.
I'm sorry.
What is it you think the judge did not credit that Ms. Hill testified to that would have helped mother?
So I don't think the issue, I think the issue is less about what Ms. Hill actually testified to, as it is that, the judge found that mother did not address the mental health concerns because of the licensure status. The judge...
But if you're relying for that on that sentence I just read from finding 32-8, if that's the only, I mean, the causal relationship that you just posed seems to me to be an awfully strong way to state what the judge actually said. The judge said many other things that concerned him about mother's attention to her mental health. Inconsistent attendance, inconsistent in terms of who she worked with, gaps in terms of working with people.
If I may, Your
Yes.
Honor. Conclusion of law 32, section 4 addresses that specifically. It discusses mother was inconsistent with her therapy appointments and was untruthful with her therapist with regards to the circumstances of the department's involvement with Sawyer. Even more concerning, mother's chosen therapist is not a licensed therapist in the Commonwealth of Massachusetts and thus is not viewed by this court as an adequate mental health professional capable of assisting mother in treating her mental health issues.
What do you say is wrong with the judge drawing that conclusion within his discretion? that someone's licensure, oh, go ahead, I'm sorry.
So there's no basis in law to find that an unlicensed therapist cannot provide therapy.
No, but cannot the judge find that an unlicensed therapist may not provide therapy in the same manner that a licensed therapist might, or in somehow draw an inference about the nature and the efficacy of that therapy?
Perhaps under specific facts, a judge could do that, but no such facts were here. There's no basis for this. There is no question about the type of engagement, and under...
What do you mean there's no question about the type of engagement?
So there's no
I mean, the
question...
judge gets to see the therapist testifies. The judge can make findings with respect to credibility and with respect to competence based
Yes.
on that testimony.
But in this case, the assessment of credibility wasn't based on the therapist's memory or her demeanor. It was based solely on her licensure status. And she was required by law to provide mental health counseling, right? So 262 CMR section 2.07, which is in the addendum to Mother's brief, it lays out the requirements for an individual with a master's degree, which Ms. Hill had. She had a master's in mental health and mental health clinical evaluation. The law requires that she undergo a certain number of hours for a minimum of 2 years before she can apply for licensure.
Can I just, I'm not drawing this exact analogy, so bear with me. But if this were a physician's assistant as opposed to a surgeon, and the issue was on a strictly medical issue, could a judge say, well, I mean, she certainly has qualifications, she's certainly competent to tell me about certain things, but I just don't give it as much weight, or I don't credit it in this way because the person hasn't achieved that level of accomplishment in their chosen field?
I think that's a faulty analysis because a surgeon has so much extra special training, whereas a licensed mental health counselor does not require any extra training. They just require years on the job. They are required to provide therapy, and 262 CMR 2.02 defines...
Read that again,
262 CMR section 2.02 defines the mental health counseling services that these individuals who are not yet licensed are required to provide in order to become licensed. So through their years of therapy, they are engaging with individuals. They're required to do that. It's not like a surgeon because a surgeon has so many more years of training than a physician's assistant.
Could I ask one other question? And then I'm sorry to keep you on this topic for as long as we have. I know you have other topics that you'd like to get to. But is there not also a requirement that a person in Ms. Hill's position be supervised in a particular way?
Yes.
And is there evidence that that supervision was in place at the relevant times here?
Yes, there is evidence. She was licensed. She was supervised by a licensed mental health counselor who she identifies by name, Ann Ash. That's at transcript 689. She was undergoing the required supervision. I believe she testified to 1 hour a week, which is at transcript 674, and then 689 to 690. And
What else do you, I think
Judge
Hand makes a good point, which is you've got a few minutes left. So what else do you want to point us to where the judge erred that you think leads to a need to overturn this?
The findings regarding domestic violence. There was no violence in any of Mother's relationships for 8 years by the time of the findings. The only other suggestion of some ongoing problem with domestic violence was that Mother terminated a relationship because there was a hint of controlling behavior. Mother felt that the gentleman was becoming controlling, didn't want her to see her family and friends. She recognized that as a red flag. She had gone to domestic violence classes. She understood that this was a red flag, that the relationship wasn't going in a direction that she wanted it to. She employed the information that she had been taught and immediately left that relationship. That same gentleman had been thoroughly vetted by the department, and they had no concerns for domestic violence. Mother was the one who affirmatively said, I felt like he was becoming controlling, so I ended the relationship.
This was Michael?
That was Michael.
Sorry, yeah.
I have a question about something you said at the outset. I mean, you asked that if we remanded, it go to a different judge. I don't see any allegation, and maybe I missed it again, of bias or of some issue other than a misweighing of evidence or not crediting evidence that should have, why can't the same judge, if corrected, just address it himself?
As discussed at Mother's brief at page 31, there was an uneven assessment of the evidence. There was a lot of conflicting evidence that did not make its way into the findings, and it was so prevalent that Mother feels that a fair trial could not be had before the same judge. It's not a bias, but just such a significant uneven assessment of all of the facts that there is case law, as cited in the conclusion of Mother's brief, that supports that this matter be remanded to a different judge so that the facts can be assessed even-handedly the way they were meant to be.
What else would you like to point us to besides domestic violence?
There were two other topics that I had hoped to reach. One was the fact that Mother had exposed the child to the eldest brother. I wanted to point out that this happened 4 years before the close of trial. It was very attenuated in time. Even at that instance, in October of 2018, it was not unsupervised. Mother and her mother, the grandmother, were both present. And Mother has successfully had unsupervised visits for more than a year by the time of trial with the daughter who was the eldest son's alleged victim. So Mother has affirmatively proven her ability to keep her children apart. She's had unsupervised visits with that daughter in the home for over a year before the close of trial. And the last item I wanted to reach was the child's special needs. There's no question that this child is on the autism spectrum. Mother recognizes that. However, she can meet the child's needs the same way that they are being met now. Most of his services are provided through the school through an IEP. Mother plans to
Was it clear error for the judge to find that the mother was resistant to the diagnosis and resistant to the notion that he needed special help?
I think, yes, it was clear error.
Clearly erroneous on these facts?
It was clearly erroneous on these facts because what they faulted Mother for was wondering whether the child had Asperger's or autism. And a layperson might not understand that Asperger's is a dated or potentially dated diagnosis.
I mean, I thought I read a finding that Mother was resistant to him having any special services at all.
I believe there is a finding that says that, but I believe that goes to the uneven assessment of the facts because Mother consistently testified, and the and Dr. Montmini, whose name I may be mispronouncing, also testified that Mother had a plan in place to have the same IEP services through her local school. Mother had also engaged early intervention with her child when he was younger. So there's a pattern and a plan in place for Mother to be able to address the services.
Make sure I understand that. The child had IEP before he was removed?
No, so he had an IEP once he started at school, which, because of his age, happened once he was removed.
He was removed at age 3. At age 3, he was nonverbal.
At 3, he had limited speech. He had been engaged in early intervention, which he aged out of at age 3.
So he had been in early intervention.
Correct.
And that was something that Mother had been involved with and taking him to. Is that right?
Yes, the services actually were provided at the daycare, similar to how the behavioral therapist provided her services after removal at the daycare. Until COVID intervened and had to be provided in home. But when the child was with the mother, she had 2 assessments done for the child. One was in 2016. He did not qualify for services because he was progressing and developing as normal. And then in 2017, he was assessed again. He qualified for services. Mother engaged those services. And so Mother has shown that she's able and willing to address child's special needs, and she's just as capable of having these services through the local school and at her home as the foster parents are. The foster parents in 2 years went to 1 IEP meeting. The child's only providers are the school for IEP services, a behavioral therapist who still sees the child after school, which Mother could accommodate, and a pediatrician. Mother could handle these obligations. I know I'm out of time, so I thank you. For any other points that I did not address today, I rest on my brief that there's no further questions.
Thank you very much.
Thank you.
So, counsel, that was 3 minutes and 45 seconds additional. I understand you're splitting your time 8 and 7?
That's right, Your Honor.
Okay. Then, if you need additional time, you're certainly welcome to it.
I appreciate that, Your Honor. So, may it please the court, Your Honor. The juvenile court, Your Honors, the juvenile court here properly found mother unfit to parent this child, where it was presented with overwhelming evidence that mother has persistently neglectful parenting history, and here has a pattern of failing to meet this child's particular developmental needs. When the child,
So let's stop there for a moment. Your sister says that the child was in early intervention prior to age 3 when the child was removed from mother. What was the neglect that was shown there?
So mother enrolled the child in early intervention in part because of the child's speech issues early on. However, once the child was already enrolled, the early intervention specialist noticed a number of additional issues and recommended to mother that the child be evaluated by a specialized clinic, be enrolled in an appropriate school, receive individualized therapy, and mother simply ignored all of these recommendations, although she later testified that she noticed a few concerning behaviors. When the child was evaluated—
When you say mother ignored, where's that evidence in the record? Or where's the finding of ignored?
The court finds that mother did not follow up with any of these recommendations. I think that's the language follow-up, and that is an explicit finding.
Where's that?
I can find that for you right now, Your Honor. Let me see. I'm sorry, Your Honor, I don't have the specific finding right now, but the court did reach that finding, that mother never followed through with any of these recommendations. What mother did instead, Your Honor, well, and I should say, when the child entered department custody shortly thereafter, the issues that were being observed were fleshed out a little bit more. The child was significantly nonverbal. The child was physically weak. The child was rigid in play, had not been potty trained, and the services that needed to be provided to the child once they were evaluated by a specialist, which again happened only under department custody, the child was was diagnosed with autism spectrum disorder and needed to be provided as part
You're talking about what happened once the child was removed, and
Sure.
I think where we were was the evidence of neglectful behavior prior to removal.
Sure.
Child's in early intervention services, right? But what you're saying is other services were suggested or indicated, and those were, in your words, ignored.
And
I need
in
to
addition,
find those findings, right?
That's correct. And in addition, mother abruptly terminated the limited EI services he was receiving at that time, and actually took the child out of state, away from family, to Ohio, where the child did not receive even the limited EI services he was receiving here in Massachusetts.
How long was the child in Ohio?
We know that mom was traveling. She was out of state for a few.
She was out of state for 3 months. Is that right?
Yeah, for a few months.
Which months were those of the
I believe it was from July to December, Your Honor, of 2018. And the child did not return to services or receive any of these evaluations until after the child came into department custody. And the services he needed were substantial. As part of the child's IEP, once he was enrolled in school, and it's not true that the court specifically found that it wasn't that the child aged out of the program. It's that, in fact, the recommendation was that the child be enrolled in an appropriate school, and that mother did not follow through with that. That required for the child to engage in not only in speech therapy, but also occupational therapy, because his motor skills were underdeveloped. The child was not accepting a range of healthy foods, including any meat, and needed to be retrained around that. And he received substantial ABA, or applied behavioral analysis services, as much as 34 hours a week after entering department custody. And yes, sir. Oh, sorry. I thought you-
No, it's all right, actually. I think I was trying to formulate a question, so you anticipated correctly, counsel. Other than, so you've pointed to neglect with respect to the child's needs prior to the time the child was removed, 2018. What else do you point to? Sort of if there's a litany here of this is why the judge's findings should be upheld.
Sure. So after the child was removed, mother missed important appointments with a specialist that actually diagnosed the child. She did question the basis of the diagnosis. And actually...
That can't, questioning the diagnosis, that can't be a basis for removal, right?
No, Your Honor.
I don't know many parents who don't question diagnoses. I mean, am I right about that? I mean, I see some things in here, and I'm like, really? That's a basis for the conclusion that she questioned the diagnosis, or that she questioned whether, you know, the sexual abuse actually occurred with respect to, those are bases?
Your Honor, I think the court properly considered that mother, at the time of trial, continued to ask whether this was appropriate. She said because he was high functioning. And regarding the abuse, she questioned at the time of trial not only the abuse regarding Troy, but even the abuse regarding which there were convictions with the father. She said, well, you know, there's a difference between touching and rape. And here...
This was trial testimony.
This was trial testimony. So for the court assessing mother's improvement over time, benefit from services, this was relevant to the court.
Understand.
And in response to...
In her trial testimony, did she also question what had happened between the older son and the daughter? Or was
yes.
that earlier? Because when I read the findings, it seemed to be was something she said almost immediately after they were reported. I didn't read that she was still questioning that at the time of trial.
Yes, at the time of trial, she said she didn't want to know details. She didn't know what happened. In fact, Ms. Hill, I believe, said that she did not want to take sides. But mother at trial did say that she did not know. She said, all I know is that my daughter said.
Had there been any resolution of the allegations by the time of trial?
Not at that time, Your Honor. And I think the court...
A basis for unfitness is that she says she doesn't want to take sides with respect to something that hasn't yet been resolved?
Certainly not, Your Honor. I think what the court does here is focus on the fact that mother did not take protective action, had not established a safe environment outside in the new home that she is inhabiting, that does not involve coming into the property.
No names.
Oh, forgive me, Your Honor.
All right.
The older child.
I almost made the same mistake.
How do you respond to Attorney Paquin's argument that essentially, and I'm paraphrasing, the mother appreciated warning signs of domestic violence and acted into the contrary, contrary to the judge's findings, that she hadn't benefited from that treatment that she actually had, and that she was sort of ahead of DCF on some level?
Well, Your Honor, I think that there's a distinction to be drawn from mother responding positively to any training regarding her own relationships with individuals that she may enter into relationships with. But she intended for the child to live along with her, along with these two individuals, very shortly near to trial, both of which did exhibit some controlling behavior, including confining mother to the home in one instance, preventing her having access to family. And if the child had been placed as mother intended with either of these individuals, the child risked being exposed to the same controlling behavior. And given the history and mother's questioning of other potentially domestic violence-related issues, the court was rightfully concerned.
So I have one other question, which is, what do you say to the argument that the judge was just made an error of law in discrediting the evidence from the therapist?
I don't think, Your Honor, that there's any citation to law that says that there's error here. The court.
Well, let me tell you what I understood her argument to be. I understood her argument to be: look, the mother chose this therapist, but the DCF was well aware of who the therapist was. DCF never said this therapist is not good enough. and then there's, a provision of the Code of Mass Regulations that indicates what is sufficient for this person to be able to actually provide therapeutic services, and she falls within it. So for the judge, under those circumstances, it appears almost fault mother for the choice, but worse yet, say, I'm going to throw it out because it's unlicensed. What do you say to that?
So I think there's a twofold response here, Your Honor. The court doesn't entirely throw out the testimony and uses it and uses the lack of licensure to evaluate mothers' rehabilitation through services generally in the context and in each of the findings cited in paragraphs which point to many other factors, including that mother missed many many appointments, not only with his therapist but also with a psychiatrist. One of the biggest concerns at conclusions of law number 6 is that mother simply did not show an awareness at trial from the testimony of Ms. Hill that it was her own lack of supervision or neglect in overseeing what was happening during these unsupervised visits when the children were in the home that may have contributed to some of the concerns, Your Honor. And so this is one factor among many. And the other, Your Honor, is that even if these are actions required for somebody to gain licensure to enter a profession, that does not mean that they were required of this individual. The individual did not need to enter the profession. Second, the qualifications of the individual are what matter here. Whether this individual actually is licensed was properly considered by the judge in reaching the weight to give the testimony.
Okay. I think we're going to have to leave it there
Thank you.
and hear from your brother, Mr. Dennis.
May it please the court, John Dennis for the child. I'm in a little bit different position, having been with the child as recently as this, or seen the child this weekend. And the child's position is he is asking this court to affirm the judgment below and to, if possible, expedite his adoption by his pre-adoptive parents. And who he has
Well,
thrived.
don't go outside the record, okay?
Right.
All right.
I'm saying that's his position.
I understand, but if you were about to go outside the record, don't do it.
I was pinching myself, Your Honor,
Okay.
beneath the podium. So the child, once placed with the pre-adoptive parents, went from being in a very, very difficult, challenging set of circumstances relating to his diagnoses and his development, which, with these pre-adoptive parents and intensive therapy and their cooperation, he, by the time of trial, had made significant progress, which is unlikely mother would have been able to provide this child.
Could I ask Attorney Dennis, I take it that your focus, generally speaking, is that the best interests of the child mitigate in favor of the outcome that the judge reached.
That's correct.
And you've gone through in some detail the allegations about clearly erroneous
Yes.
findings in your brief. So without getting to those, can you, what's the child's position with respect to the mother's contention that the judge failed to engage in an even-handed assessment of the evidence that was presented?
Well, as I pointed out in my brief, the judge did pay close attention. And I might mention the findings are kind of hard to follow because the numbering is not sequential. And I don't know if anyone else had that problem. But I'm sorry, what did you say?
The question about the even-handed assessment. Attorney Paquin.
Yeah,
makes
okay,
an
what I
argument about
argued
that.
was, the big picture is how many findings the judge made with respect to mother's credibility. She the judge, and I don't know how you can undo the judge's credibility findings here after having listened to Mother and all the other witnesses in the case. But on almost every major point, the judge made specific findings that Mother's testimony was not credible and that she would change her testimony during the trial. So I think that's important for a number of reasons. One is the matters on which she was found not to be credible included danger to the child by exposing the child to the older brother with her grandmother, the grandmother, who's the only person she's able to live with, apparently. And the oldest child also lives with that grandmother. And despite the department's direction that that was a threat and a danger to the child, the mother did not testify credibly about her efforts to protect the child from that situation, even though she acknowledged that she should have to do that. And the grandmother, in addition, in seeking placement, was also.
That older child is now 24. And I didn't understand, even from the findings at the time of trial, that he was living still with grandmother. But what do you rely on for your statement that the judge didn't credit the mother's testimony about her keeping the child safe from that situation?
Finding 145, 149, 160, in particular,
145, 149.
and 160. There may be more, but those I've cited in my brief. .145, the court discredits mother's testimony. She was told by the department she could continue the overnight visit with her older daughters in the home the oldest brother was residing in right after the disclosure of the sexual abuse. The court
Does not credit mother's testimony as to the timeline of her informing the Department of Emma's disclosure. And what's the third one? 160?
Yeah. That he doesn't credit mother's testimony that she didn't know the oldest son was in the home when the Webster police came. And there's plenty of evidence in the record that mother was living there.
There's one thing that I didn't understand, and I don't know if I want to, but there was in mother's brief, there was a reference to the fact that some finding, and I think it's the one with respect to how quickly mother responded to the disclosure of the daughter, that was overturned at a fair hearing?
That's the wrong. I think what was overturned at the fair hearing related to the 51A that had to do with the episode where mother was driving under the influence and had an altercation with her sister.
Okay. What else do you want to tell us about? You got another minute or so.
Well, as I said, I think my main point, domestic violence, I do think, is an ongoing concern, as the judge found. Mother has a history. This is the 10th of mother's children. She has custody of none of them. And I think that's not stale. It's prognostic. And this child, were he to be placed back with mother, he'd be, I think, in danger.
Okay. Why don't we leave it there, counsel? Thank you all. These are very difficult cases. Appreciate everyone's advocacy on behalf of their clients. Next case, uniquely identified as Doe v. Sorb. With counsel who have little experience before this court.
Morning, Your Honors.
Why don't we wait for Mr. Shanai to have a seat and get himself organized?
I'm fairly organized, Your Honor.
I didn't read the number. This is 22P 1062, and Mr. Burkholder, you may proceed.
Good morning, Your Honors. Fred Burkholder on behalf of John Doe, 526-599. My brief says what I really need to say, but I'd like to respond to a few things that my brother brought up.
Can I ask one question, Mr. Burkholder, before you do that, trying not to interrupt your flow? Is it your view that there can only be one, if there is a like offense, there can only be one?
Well, it's a great question. And I'll tell you why I answer it that way, because if you look at I tried to take a look at the Massachusetts statutes, the numbers of them, as well as the number of federal statutes. And this morning, I found 18 U.S.C. 2422, which is coercion and enticement, which was passed in 1970. And they all flow out of the same Mann Act, which is now 65-some years old. And that was in existence before. And so there's a number of variations. It's interesting, and I'll try to answer the question by one more thing. 2421, as I see it, was just a general framework. I actually have a statute that says
2421 is the one that she was, I'm sorry, that he was convicted of?
Yes.
Okay.
Yes. And go ahead. I'm sorry.
What's the answer to Judge Hand's question?
Well, the answer to the question is, I think that, yes, I think there's a limited interpretation of the meaning of the statute, and if I understand the law correctly under the rule of lenity, ambiguities are supposed to be decided in my favor rather than the board's. And if you look at the statutes here in question, I mean, my brother admits that there's a statute that matches. And you know what? I don't disagree. It says
Why isn't that the end of the case is the question I was going to have.
Well, it's very simple.
I'm not sure you've yet answered Judge Hand's question.
Well, I think I did, in that I said I think there's only one matching statute, and I think my brother pointed it out. And why is it the end of the case? Because why do we have records?
But this is my question, I guess. The reason that I'm asking it is because the definition of a like offense it seems to me, is reasonably clear that it doesn't have to be exactly congruent.
Exactly, without a question. Doesn't have to be identical.
If that's the case, then how is it not possible that there could be more than one like offense? And if that's the case, then the fact that there's one that may be a better fit doesn't mean that this particular one that the examiner relied on wasn't arguably a good enough fit.
I think having spent as much time as I did looking at the specific language of these statutes, I can only speak to these. I can't speak to the realm of Massachusetts and federal statutes that cover the scope of prostitution. I can tell you I think these are different. And I don't think that those minor differences are enough to look past. I'm going to go to Justice Engelter's question, first of all, and that is, why does it end the case? Because contrary to what my brother cites, which is Cape Cod versus Collaborative, where he says that shouldn't be the end of it, we can do a de novo hearing, that case only interpreted a statute. It didn't say, here's a new one. We get to apply that. And that's what my brother would like us to do. And here's the problem with that. The problem is that the requirement was established so that individuals, when they contemplated pleas, would have notice and clarity with regard to the ramifications of their actions. And in this case, interestingly, the federal district judge was asked in a declaratory action whether or not this is a sex offense, and he said no.
Under federal law.
Yes,
correct?
Under federal law. So that's the understanding that my guy goes into this plea. He sees it as such. I don't know how competent his attorney was with
But
regards
I don't know, why is that, okay, let's accept all that you just said is true. Why does that matter? I mean, as I understand the question, as it's been framed by your appeal, it is, did this person have to register as a sex offender?
Exactly.
under, and I thought I had the statute in front of me, but I don't. But it's the like offense provision, right?
178C.
Okay. Now, you're saying, look, I think it is a like offense to the human trafficking statute. Means he has to register as a sex offender.
No, they can retry it. They can replead the case. Otherwise, we're stuck with, here's my problem.
What do you mean replead it? There was no pleading in this regard,
Well, no,
was there?
they can re-attempt to classify him and fight jurisdiction under that.
So, so there are a lot of words running around, one of which is jurisdiction. And let's leave that aside because I'm really not sure whether that's the right word.
But that's the whole key to the case. The whole key is,
The question is whether he has to register as a sex offender.
and in order to do that, you have to have jurisdiction. In order to have jurisdiction, you have to have a like offense.
They have jurisdiction to decide their own jurisdiction, don't they?
No. No, because the courts have interpreted.
Let's assume with me that they have jurisdiction to decide their own jurisdiction, okay? As I understand your argument, it is they picked the wrong like offense,
Bingo.
right?
Bingo.
Okay? And do we have anything in the record that tells us how that happened?
Yeah, it's done by the hearing examiner. And I'm sure.
So was there any articulation by anyone as to what the like offense was or was not before the hearing examiner rendered their
It's a
decision?
great question, and I would have to tell you only because I didn't look at that. Of all the things I usually look at, I didn't look at that. But generally what happens in these cases is this. The attorney representing SORB submits, here is the proposed statute that applies. And I think that happened in this case. Here's the proposed statute that the individual is convicted under. And then here's the proposed statute that is a like offense to, and then the hearing examiner gets to make a determination based upon that. So does he just pick it out of the air? No, I believe it's generally. And I can pull up the record.
Would we have it in the record?
Well, first of all,
what was argued by SORB to the hearing examiner?
it would be one of the exhibits. I don't know if I brought it or not. It would be one of the exhibits that was admitted. And I didn't bring it. The last thing I pulled out was what the exhibits were.
And how was it presented to the hearing examiner that I don't have to register? I have not committed a like offense. How was that presented?
Here's the way the procedure starts. An individual receives a notice that says, we have pre-classified you as a sex offender and you have to register. The individual then has the opportunity to request a hearing. Prior to that hearing, they have the opportunity, 10 days prior to the hearing actually occurring, to submit evidence. Prior to that 10-day period, the board provides us with their record, and we now have all their proposed exhibits.
Okay, so let me just stop you because my question was very distinct. How was it presented in this case? How was it presented to the judge that this is not a like offense and I don't have to register?
It was presented in the proposed findings of fact and conclusions of law, as well as was presented during the hearing.
Okay, all right. So I'll be able to find that in the record.
Yes.
Okay.
And then it was presented again at the Superior Court level before.
What do you think we should do? Let's assume that we
Dismiss
agree with, dismiss it.
Yes. You don't have here's the problem.
You were going to say jurisdiction again, weren't you?
Well, you know, Judge, that allows them to act. Under the statute, it says that if in fact you are convicted of an enumerated offense,
And you have to register.
Then you have to register. And yet, because enumerated offenses do not include other jurisdictions,
Why wouldn't it just be a remand?
because otherwise what you're in essence doing is saying you're not bound by the record. And you know what? I can bring in a stack of cases where I try to introduce other pieces of evidence, and what do I
I
get?
don't understand what you mean, we're not bound by the record.
Well, I mean,
Well,
let
why
me
wouldn't
give you
it be a
an
remand?
example. Let me give you an example.
You are mistaken, assuming that that's true, you are mistaken that that this statute that's been identified in the opinion is a like offense. We're remanding for you to address the question of whether there is in fact a like offense so that this person has to register.
That is not what happened in Where is it? I brought it. I know I brought it. Oh, here it is. That is not what happened in 346132. Decided June 18th, 2014.
The published opinion?
Yeah. I don't see any 123 or
What's the
otherwise
site?
on it. It's cited in my brief. And at the end, it says judgment reversed.
What's the site?
Citation is 85 Mass Appellate Court 482, Appeals Court of Massachusetts, 11 Northeast 3rd, 153, decided on June 18th, 2014, and it was decided by,
I got it. You can proceed.
okay,
While Justice Englander is reading through the case, he's going to pull it up for you there.
please.
Can I just circle back just so I understand your position on Justice Hand's first question on like offenses? So now just put it in maybe terms I can better understand. So assume for the moment in the criminal law, malicious destruction of property and vandalism are very close cousins, if you will. And the federal statute is like malicious damage, but it's really on all fours with vandalism, okay? But the board goes with malicious damage. You're saying that then if there's another statute that's pretty similar, in fact, very close, but there's a slight technical difference, that's not enough. It has to be the...
I think there's more than a technical difference here,
Okay.
and the answer to your question is yes.
Yes, you do.
And I
Okay.
think this case
All right.
says that should be the law, and that's what this court has done in the past.
Hopefully we'll get, okay.
I mean,
I just want to make sure that's all. I think you said it. I just want to make sure I understood it more
In essence,
clearly.
I'd like just to point out a couple things with regards to the differences. First of all, the conduct in question that the individual was convicted of, first of all, he was charged with 3 other charges, all of which probably were closer to what we have in Massachusetts. Those were dismissed. The individual in question no longer was a minor. The offense he was convicted of was when she was 18 years old. As a result, he's convicted of what he is. That says simply knowingly transport. That's all it says. That's what transporting for servitude, which is the offense which they should have cited him under, 26550 says.
Well, this was written by Kafka. I mean, why would we
Oh,
want to pay any attention to that? I mean, that case, it seems to me, there wasn't an argument or any indication, hey, there's another statute that is a like offense.
Well, no,
right?
but
I mean, there is a comparison between kidnapping and some sort of sexual offense, and the court reaches the conclusion that, kidnapping in, I think it's Maine, is not a like offense to any Massachusetts sexual offense, and therefore the board, there was no obligation to register.
And that's what I'm saying is the situation here. And why am I saying it? Because the conduct in question, not only are the elements different, because under the
with respect
Massachusetts...
to this particular offense that is identified in the footnote of the hearing examiner's decision, right? But there's another one. There's another one that you concede is a like offense, and it is a like offense as a matter of law. Can't we reach that conclusion as a matter of law?
They can start over again. No, can you do it as a matter of law? I haven't found any support that says that you can. In the case that my brother cites was an interpretation of an existing statute. It wasn't a substitution of the statute. Because here's what I want to draw by analogy. When I come in here and I argue a factor is inappropriate, the court says to me, under 22188, the second one, the most recent decision, it says, you know what? That's not something that's within our scope of responsibility and expertise and the like, so we're going to send it back down to the board. So you don't just substitute it, take it out, and say otherwise. It gets sent back down to the board. This case is different. This is not about what the classification should be. This is about, should you be able to classify? And I'm going to go back to the original thing I said before, which was notice and clarity. That's what the individual pleads upon. So if the individual can then plead anywhere in this country and say, I'm going to do this, and then he can wait until this court or another court gets to say, well, I think we found something that it matches and you get to register, especially when a federal judge has said, no, it doesn't match any of the SORNA requirements.
But Attorney Burkhalter, how does that work? Maybe I'm missing the gist of your argument, but if your client was pleading in federal court with a determination that it is not a federal sex offense, so there's no issue there, there's no allegation here that his plea was contingent on the Massachusetts interpretation of the Sex Offender Registry Board, right?
There is not, but I mean, the last question that I guess we're going to talk about, or I'm going to raise, is this, and that's full faith and credit. Because I've made that argument in other situations with regards to a federal determination that was made concerning things.
The state statute can be different than the state sex offense definition can be different than the
without
federal.
any question.
So where does full faith and credit have anything to do with it? What are we giving full faith and credit to? We can be different. Your time has expired. You've been very helpful. And
Doubt that, but
unless my colleagues have any questions,
Thank you.
we will hear from Mr. Shinai, who I think can anticipate we're going to have some questions for him.
Thank you. You know, if it pleases the court, David Shania for the board. I think 34123, it was actually my case, and it was a different set of facts. And I believe the case, the facts actually came out of Rhode Island, and it was a horrible case fact-wise, and I think that's why the board went forward. In fact, it's in the top 5 of cases I wish I didn't know the facts of. It's just
I've
a
known
horrible.
2 of your top 5. By the way.
You know, in this case, I think you have to start with the premise of that you have de novo authority in this case to make a decision as to whether or not a like offense occurred.
Let's start with, I think, what Judge Hand was asking your brother about. Do you concede that the crime, the state crime that was identified is not a like offense? And if you don't concede that, what's your argument?
I don't concede it. I say that there's 2 possibilities as was being asked in this situation, but 272 Section 2, it comes down to what the essence of the crime is. If he did the same acts in Massachusetts, could he be convicted of under 272 Section 2? And the board's
Case law
position
says
is
you
yes.
look at the elements, not just the conduct, right?
It doesn't, but the elements don't have to exactly fit. They just have to really come down to the essence of the crime. The individual took a young girl from elsewhere, say, as the statute allows, for prostitution. Is exactly what he did under the
Put
federal
another
law.
way, you're saying that the test is conduct-based, not element-based.
It's
You look at the
element-based.
conduct, and if the conduct fits any one of several possibilities, that's enough, as opposed to, even though it may not exactly have matching elements?
It's a combination. There was a case I argued that was successful. I can't remember the name of it, but it was a statute out of Washington, D.C. And in that case, the individual, it was sex offense against a child under D.C. law, 18 or under. And in that case, our victim was, I believe, 13. So I was able to argue, sure, it doesn't fit exactly, because 18 and 14, which is the statute under indecent A and B, don't actually line up for the age of consent. The court ruled that the conduct of sexually abusing a 14-year-old or 13-year-old would have caused conviction in Massachusetts for a registrable sex offense, which is indecent A and B under. And therefore, it's a combination of the elements as well as the conduct itself.
So is your following, can I just follow? So is it, just to follow that up, so then does that mean, am I missing the point, or is your argument that if, rather than alleging it under the indecent A and B, if the facts fit better under rape of a child, which is still under 16, so the Washington, D.C. statute would be satisfied, it's alleged as under the indecent A and B under 14, but the facts are really more of a rape under 16, doesn't make a difference?
Doesn't make a difference because he wasn't charged with a crime that included rape. He was charged with, and I think I have this right, I'm not sure if it was rape or indecent A, but using the indecent A and B fact pattern, because he wasn't convicted of rape, the board can't find that he committed rape. But since he was convicted of indecent A and B, the victim in that case was under 14, we can then look at and say, well, wait a minute, it wasn't indecent A and B, and in this case, the victim was under the age of 14. In Massachusetts, he would have been convicted of, or could be convicted of, indecent A and B under. So that's why you get kind of a combination.
But here, this is why I have difficulty. I think the language is fraudulently, enticing fraudulently, or there's another adverb.
Deceitfully.
Or what?
Deceitfully.
Deceitfully, yes. And that's the language of the state, of the Massachusetts statute that the hearing examiner relies on in the footnote, right?
Correct.
But as far as I can tell, there was no evidence of fraudulent or deceitful enticement with respect to his federal crime.
This is true. That's why I fell back to 265, Section 50, just in case. I didn't rest everything on that one.
We were on issue number 1 first, which is whether or not the fraudulently and deceitfully is a like offense.
Well, again, the board's not conceding that, but the board at the same time is saying 265-50 is a better fit. And because of your de novo powers, remanding it back to the board so that they can make that determination really doesn't.
So help me, de novo powers is a very interesting sort of 3 words in the air. But there are these cases that say that we can't reach a decision that affirms an agency action based on an argument that the agency did not put in its findings at the time.
Unless, and this is the big unless, the one issue that can be brought up at any time, in any level of appeal, at any stage of proceedings, is the issue of jurisdiction, which this is coming down to. Do we have jurisdiction? And in that case, this court has the authority, because it's an issue of law, to make that decision if need be.
So let me see if I understand that. That argument is, we relied for our basis for him having to register on the wrong statute.
Correct.
But what we want you to do is affirm, because there's another statute that applies, and because it's a question of jurisdiction, you can do that.
Well, not conceding the first part, essentially yes.
All right. And we can do that despite the case law that says that we can't rely on a rationale not articulated by the agency?
If this were a substantial evidence case, which for the first time in a long time, I haven't had to write a substantial evidence case, that would hold true, that you don't have the authority to go beyond what the hearing examiner theoretically wrote and decided on. But a jurisdiction case changes. That's a different animal altogether, I guess.
I don't have a case that says that, though.
I'm relying on Cape Cod Collaborative, but I think there's other cases in that
I couldn't
line.
find it in Cape Cod Collaborative. I read it this morning. Maybe I'm just not reading very well these days. But I couldn't find something that said, well, we can ignore the agency. There's nothing new about this restriction on what you can look at in administrative law, right?
I think DOE 523391 also says that legal issues can be determined de novo in front of this court. So,
well, legal issues
and jurisdiction is a legal issue.
Legal issues can be determined de novo, but I'm not sure that means that we get to affirm on the basis of a legal conclusion that was not relied on by the agency.
And, I think that's the crux of it. If the court says that if you believe that that can't happen, of course, it goes back to the board on remand. If you believe or if you find that you can make that determination, I think it stands.
Brother says that we have to dismiss it.
No, I think that the remedy of this is to send it back to the board for the board to make a determination as to whether or not it has jurisdiction.
And they have to somehow reallege what's being alleged, or something. I mean, what do you do with the record that indicates that we're?
I think if you remand it, it's going to end up being an amended decision based on the finding that a different statute applies, particularly in this case. That will start the 38 process again.
Right.
And by the time that's done, he'll probably be about four years past his chance for a reclassification. So it's a kind of a dilemma there for
I
them.
ask this question, it may not matter at all, but I'm looking at the record and I see that Doe had proposed findings and rulings, which if I am reading correctly, essentially say there's no like offense, it doesn't exist. And I don't see that the board put in proposed findings in this particular case, at least that were noted as part of the record. Is that
No, I would say they did not.
Okay.
Generally, that doesn't happen, just like, I think my brother attorney was right. The attorney for the board introduces the statute that they believe applies, and the hearing examiner works from that because,
Do we know whether that happened here?
yeah, I would guarantee it, because what happens is, and I'll tell you the process,
Where are we going to find in the record?
you'll see a copy of the statute in the record.
That's it? There's not going to be something that says the reason that this is a like offense is Mass Statute X. That's not going to be there, we're just going to have a copy?
Well, the attorney, and I'm not positive, I mean, if it was me, I would have, in the beginning, at my opening, tell the hearing examiner, this is the statute that applies as a like violation. So that being the case, my sense is that,
It's not the examiner that picked the wrong, in your view, what likely happened here, it's not the examiner that picked the wrong statute, it's the board that picked the wrong statute.
right, because when an out-of-state conviction comes in, the board attorneys assigned to determine, is it a like violation? If it is, they send it back up the chain to start it for the hearing. So it originally begins with a board attorney making that determination. Now, if the board attorney, and obviously possibly, again, not conceding, but may have made a mistake in this matter, and it went forward from that because that board attorney probably handled the next level up, which would be the hearing. And I think I briefed this fairly well in my memorandum. Again, the position is that 272.2 does apply, and a fallback is that 265.50 is more in tune with the federal statute, and if the court finds that a remand isn't necessary. So based on that, I'd be more than happy to rest.
I take it's your position that we could conclude as a matter of law on this record that the offense that he was convicted of is a like offense to Section 50.
Correct. That's in it. That's down to. That's it in a nutshell.
I think we've got it.
Thank you.
Thank you both.
Exhibit 1, 134 to 136, the federal statute was in there.
Thank you. Exhibit,
What did I say, 134 to
136 heads, counsel, that's what you said.
Terrible.
Anytime.
He didn't say anything about the state statute, but the federal statute was in there.
He said it so fast, I'll never remember it. So.
thank you both, gentlemen. Okay. Case 6, I apologize if I don't do very well with your name, sir. AL-KARIM DHANJI.
Yes, correct, sir.
Versus the Massachusetts Department of Veteran Services, 22P 1067. You may proceed, Mr. DHANJI.
May it please the court. My name is Commander AL-KARIM DHANJI, retired United States Public Health Service. I'm a 24-year veteran. During my country, I've served my country honorably. I have deployed nationally under presidential directive, and I have served during wartime. I have performed service in the Army when I was detailed at Madigan Army Medical Center in 1997. This case hinges on 3 questions. Based on the case law, I believe they're subject to the de novo standard of review. Contrary to DVS's position that this is a case about adding words to a statute, that's not the case. This is a case of statutory construction and using all the tools available to get at the legislative intent of Chapter 115. To understand what was stated in the case Worcester v. Quinn of the statute's liberal and beneficent spirit, does the term perform service in Chapter 115, Section 6, as defined in Clause 43, is it so restrictive that it can only mean membership in the regular armed forces?
But Dr. DHANJI, excuse me for interrupting you.
Sure.
Do you prefer doctor or commander?
Commander would be appropriate for this.
I appreciate your service. Thank you for that. Do you disagree, I take it, with the department's point of view that this is a question about statutory interpretation of the Massachusetts statute and the meaning of the word veteran in that statute?
You know, if you look at Chapter 115, Section 6, it defines veteran, and then it says a person who performs services as defined in Clause 43. So ultimately, it is getting down to what performed service is.
But it identifies only certain branches of the military as veterans for the purposes of that statute. Is that correct?
Does it?
That's
Or
my
does
question.
it define certain types of services, active service, wartime service, denying active duty for training? Does it define membership? Membership is only limited in Clause 43 to Merchant Marines and Coast Guard Auxiliary. What it does define is a person who has served.
If we were to take a different view
Okay.
and say that the statute is limited to those branches that are identified by name within it, how does that impact the rest of your argument?
If that was the case, if that was the view that it's only limited to those membership, then frankly, I'm not a member of the United States Army, Navy, Air Force, Coast Guard, or the left-out branch called the Space Force. But I don't believe that that's the view.
Okay.
Okay, so I do believe that basically it basically gets to the work, the service that was performed by.
Let me see if I can understand your question,
Sure.
your argument a little bit better. I'm looking at Clause 43, Chapter 4, Section 7. Seems to me that's where we should look, because that's what 6A
Right.
tells us to look at, right?
Right.
6A says, perform service as defined in Clause 43 of Section 7, Chapter 4, so I look at that. Veteran shall mean any person, and it's last discharge or release, you satisfy one, I believe, or you satisfy A. Shall mean and who, B, served in the Army, Navy, Marine Corps, Coast Guard, or Air Force of the United States, or on full-time National Guard duty for not less than 90 days active service. Now, what is your argument as to why you satisfy B?
Because I have served in the Army. Because that definition, if you look at, for example, what service means, service does not mean membership. Okay, service is not restricted to only membership. And what I can say is, if you look at Appellant 89, I believe, it was the Mass Attorney
And what is the
General's-
evidence? So I saw this reference in your brief, but I have to say, it didn't seem to me to be the argument that had been made below. So where should I go to find the facts that support the position that you served in the Army for more than 90 days? And where should I go to find that you made that argument to the administrative agency?
Okay, well,
Or maybe to the Superior Court? Let's start
so
with the
the argument that I
administrative
made, I served in the Army, was made in my hearing office my appeal where I stated that I was on detail in the United States Army.
I'm sorry, on your appeal to us?
On the appeal to the hearing officer originally, okay? So I am making...
How did you make that? Did you
No,
provide
I did
evidence?
also document an attestation that I had served in the United States Army at Madigan Army Medical Center. I was subject to the laws of the Army. I was subject to the Uniform Code of Military Justice. So that is me saying I served. That is not me saying that I was a member. That means I served. Now, I look at this because I obviously don't want to make things up. The Attorney General made an opinion about this word, served in. And I referenced it in my brief, I think it's Appellant 89, where the Attorney General was asked in 1950, I believe, this is a public health service officer. They are being detailed to the Coast Guard. Do they meet the definition of served in the military and naval forces? And the Attorney General answered in the affirmative that yes, they do meet that because they are going to work in the Coast Guard. I, as a public health service officer, worked in the Army.
That's an opinion of the Massachusetts Attorney General?
The Massachusetts Attorney General.
In 1950?
Yeah, I think
coming out
it's-
of World War II at a time when the public health service, as I understand it, was considered to be part of the armed forces.
No. There's 3 conditions where public health service officers, on account of their active military service, are considered entitled to the full rights benefits of any Army officer. Okay, those 3 conditions are a member of the military branch of the armed forces, okay, on detail to the armed forces, or during times of war. That is 42 U.S.C. 213A. Okay, separately, just to use this concept of served in to get to the point of the matter is, during that time, the Attorney General also was asked about merchant Marines, which is included in the current definition of veteran. And they said, no, they're civilians. 1989, fast forward, now the Attorney General is asked the same questions. Hey, are the merchant Marines veterans? Attorney General answers in the affirmative. They haven't become members of the armed forces. They have become veterans because they have been deemed by the United States to have served in the active military service. And
what are you citing to us now?
Well, that current citing is the Attorney General opinion that's in the briefs that was
from 1950.
No, the second one is from 1989 that was from Attorney General Shannon to Secretary of Health and Human Services, Secretary of Health Services Lashman, which basically looks at how the veterans pre-enactment were defined as veterans.
Commander DHANJI, can I ask you to turn your attention for a moment, unless they're all set on this one? I just wanna go to the next
go
issue.
ahead. Yeah.
To the issue of preemption.
I'm sorry, sir.
The issue of preemption
Oh,
that you
okay,
raised.
sure.
So can I first ask, do you acknowledge that the argument about field preemption, excuse me, the first time you've raised that is here, that you did not raise field preemption as opposed to conflict preemption previously?
Yeah, I didn't understand that argument. Field preemption is when the Congress takes over everything. Okay.
I know what it is. I
Okay.
do know what it is. I'm asking
well,
whether you've
yeah.
raised that issue
Well,
previously.
but the funny thing is, I don't know if you realize this. This area of law we're talking about, is it a historic police power? Is this the power that Massachusetts was born with?
It's a great question. Great question, sir.
It's an area.
Sir, but hang on. If you could just,
Sure.
just stick with me for a moment,
Okay.
and then.
So I'm
feel
not
free.
arguing that this is a case of field
You are
preemption.
not. Okay.
I'm arguing that this is
And
a
so
case
let's talk about
of
conflict preemption.
conflict and impossibility
All right.
preemption.
And so in what way, at least as I understand, and I confess that it's a relatively recent understanding, and probably not a full one.
Right.
But in what way does the Commonwealth's annuity present an obstacle to a federal law? Since it just seems to me that there are 2 different tracks, and the state gives additional benefits over the federal.
Okay. So this is not about the issue of the state being entitled to give additional benefits.
Okay.
Okay. Quite honestly, in the history of this country, in the history of the state, that was different when this country was founded. The pensions of the colonists, if you would even agree to them, were all transferred to the federal government. That power was solely in the federal government. This power to raise and support armies was never the power of the colony. It was the power of the crown. It transferred to the power of the Continental Congress, and then it transferred to the power of the United States. I cited in Texas, Torres versus Department of Public Safety, a comprehensive analysis of that this state's power in this area of law is not based on sovereignty. It was transferred to the United States of America, okay? But somehow, the Massachusetts seems to think it has a source of power in this area of law. So getting to the issue of the conflict and the impossibility, the conflict is presented not based on the provision of benefits. It's presented based on the discrimination of Congress's veterans. Veterans that the Congress has stated under 42 U.S. 213A should be entitled to all the rights, benefits, privileges, immunities as an officer of the United States Army under all the laws of the United States. Now, I hate to say this, and I've been thinking about this word. In the beginning, when I was trying to discuss this reasonably with everyone, I, for some reason, I feel like gaslighted is the term, that I was told the laws of the United States are not the laws of Massachusetts. They're just the laws of the United States. But since then, I have found out, based on the Supremacy Clause, that the laws of the United States are the laws of the land. And if the Congress has stated that under the laws of the United States, public health service officers under these conditions are deemed equivalent, then it is not for the laws of the states to say, you know what, we don't believe in supremacy. And then I thought, well, maybe we're confusing the laws of the United States and the laws of the lands for the laws of the several states. So I was very fortunate. The laws of the United States are the laws in the several states, and just as much binding on the citizens and courts thereof as the state laws are. Hines v. Lowry, 1938. So this is the conflict, is because Massachusetts is saying from some source of power that it can discriminate against public health officers, not in the general term, because generally Congress wants its service members to be treated equally as veterans. Benefits, pay, legal protections, USERRA, everything Congress has deemed that.
Could the state make a decision that it was going to provide additional compensation to someone who's been injured and to no one else?
Pardon me?
Could the state make a decision that it was going to provide additional compensation to someone who'd been injured in active duty and to no one else?
And to no one else?
Yeah.
Can it provide additional benefits?
Yeah.
It can, as long as it doesn't run afoul of Congress's power to raise and support armies.
Well, would that, do you think, in your view, would the state deciding that it was going to provide additional benefits, some annuity,
right?
If you've been injured in combat, could they decide that?
Yeah. I mean, they can decide that if they're going to just give an additional benefit.
They decide that they were going to just give an additional benefit to those people who participated in combat.
To those who participated in combat. If they're using terminology that does not reference the term veteran, if they're not giving that person a status in the state called veteran, then I guess, yeah. And they're basically making a claim that's independent of their status as a veteran. Okay? The point being, I'm sorry.
No, that's all right. Can I understand your answer, which is an interesting answer. So the argument off the top that we spent some time on was your contention that you satisfied the statutory language because you had served in the Army. Looking through the decisions of both the agency and the Superior Court judge, I do not see anything that addresses that argument. Now, usually when that happens, it's because the argument wasn't raised before them.
Well,
so, am I right that, do you
no,
agree
you're
with
not
me they
right,
didn't
because
address it?
I
No,
did.
no, sorry, let me finish the question.
Sorry.
Do you agree with me that they did not address it?
No, I remember the chief counsel basically made a point, well, you were on detailed in the armed forces, but, we have groundskeepers who are civilians who serve on Army bases. So they addressed it. They said that we don't recognize
In
people.
either of the written, they gave written decisions. There was a written decision of both the.
Yeah, I mean, the hearing officer didn't, but it is in the administrative record. You know, I mean, it was kind
Where
of,
am I going to find in the administrative record that you raised this argument before the agency or before the superior?
that I was detailed to the armed forces.
I qualify because under the plain language, I served in the Army. Where am I going to find that argument?
It's in the administrative record that I documented that I had been detailed to the United States Armed Forces, and that as such, I had served in the Army. And their argument was
I therefore satisfied the statutory language.
that satisfied the statutory language that is supported by Attorney General opinion, that is supported by their own interpretation of merchant marines, satisfying the requirement, but instead they chose to say, we don't recognize people in partnership. Well, the funny thing is, as I was reviewing the documentation for this trial, you know, the state of Massachusetts actually recognized public health service officers in 1946 who were on detail to the armed forces and offered them a bounty.
Was one of those days, I know this is a minor point, but was one of those days during wartime that you're being detailed?
Well, yeah, that was during wartime, and technically we're still under wartime. 1990 till today is a time of war in the Massachusetts.
What was the point what was the time of your detail?
My detail was during 1997 to 2000. It was during the period of wartime, which is defined in Massachusetts statute from 1990 onward.
Okay. I think we're going to have to leave it there unless my colleagues have questions. Thank you very much, sir. And this is Ms. Bolanos.
Yes, Ms. Bolaños for the Department of Veteran Services. I'd like to address the issue of waiver. I don't believe that the argument that Commander DHANJI served specifically in the Army such that he qualifies for this benefit was squarely raised before the administrative agencies. And just as an example, page 47 of Commander DHANJI's brief to DALA says, the issue in this case is whether my service in the United States Public Health Service qualifies me as a veteran for this Massachusetts statute.
So yeah, I agree that there are portions of many of the documents in this case that indicate that that was the way the issue was presented. But Commander DHANJI says if you go into the administrative record, you will find that he also made an argument that he served in the armed forces, or he served in the Army. Are you telling us you don't think so?
I did review this. I don't think it was clearly made. What I did, but you know, there's a possibility I could be mistaken. But what I did find is take a very close look at what facts are in this administrative record. And one fact is page 20 of the supplemental record appendix, which is the document from the Veteran Affairs that discusses his service history. And it lists branch of service, United States Public Health Service, character of service, honorable, and dates 1992 to 2017. So even the Veteran Affairs, which is the federal agency that governs veterans benefits at the federal level, views Commander DHANJI's service as service to the public health service, not service to a different branch, such as the Army.
If he had raised the argument, assume that he raised the argument, we go back in the record and the argument is raised, I qualify under the plain language of Chapter 4, Section 7 because I served in the Army and that meets the plain language. What would you say to that?
I'd say first, the agency reasonably relied on the federal government's characterization of his service as service in the public health service. And he did supply an affidavit at page 55 where he does say he had a duty detail with the Army at the Madigan Army Medical Center in Washington. That's not an argument that he should qualify because he served in the Army, but that fact is in the record in an affidavit that he characterizes it as a duty detail with the Army. And he also says what he was doing at this time was completing a residency in family practice
Does this turn
medicine.
on the question of what served in means?
I'd say it is an interpretation of served in, but I think it's a reasonable interpretation to view served in as what service branch an individual is a member of, including as categorized by the Federal Veteran Affairs.
Okay.
So I do think the argument was waived, and there are facts saying that he had a duty detail with the Army in an affidavit, which also clarifies that it was when he completed his residency, but I think certainly there should be deference to any findings of fact that were made based on his service being in the public health service and reliance on.
Where were there findings of fact that we would have to defer to on this issue? They didn't address this issue. Neither, am I correct that neither the administrative agency nor the Superior Court judge addressed the issue of whether he served in the Army for purposes of Chapter 4, Section 7?
Yes, that's correct.
Okay, so what would we be deferring?
Well, to the extent that the court can, well, the evidence in the record, then I'll reframe, the evidence in the record does not support his contention raised now on appeal that his service was in the Army.
All right. Other questions? I have some, I think, but go ahead. You have other things you want to tell us?
I'd also like to note that characterizing the family medical residency as service in the Army also runs contrary to 42 United States Code 217, which says that the president has authority in times of war to declare a member of the public health service as part of the military branch. And so a reasonable inference from that is that when not in a time of war and not subject to this presidential decree, members of the public health service are not members.
He says that it was a time of war. Is he wrong about that?
The Persian Gulf War, it's correct that the statute has not closed off the time frame for Persian Gulf War, but there's no presidential decree in place
point,
during this time.
But relevant. Understood. What do you do with Reynolds?
One, Reynolds is factually distinguishable.
Why?
Because here, the question is whether someone whose service was in the public health service qualifies as a veteran outside of the traditional 5 military branches of the Army. In Reynolds, the individual there had served, it was undisputed that he had served for 4 years in the Coast Guard, which is one of the military branches, and the question was whether or not his discharge as a conscientious objector disqualified him, notwithstanding those 4 years of service. There's also...
yeah, the facts are different, but you have and it's not at your ordinary district court. They say, look, the distinction that's drawn, the conscientious objector distinction that's drawn by state law in this very same section is unconstitutional for one reason or another, but at least, let's say, potentially equal protection, because it draws a distinction that the federal government does not draw, right?
Right. I'd say there, in terms of the preemption analysis, arguably the conflict was more direct. The case is not clear on this, but there's a question of whether or not the state's decision not to recognize the plaintiff there as a veteran impeded his ability to access his federal educational benefits.
So I was having trouble with that. If that were true, if the case was only about accessing his federal educational benefits, then it's clearly different. But it seemed to also be about his ability to access his state benefits. In other words, the court also seemed to be saying, because the state has drawn this distinction for purposes of state benefits, it's unconstitutional.
That's right. And I'd say the third point to that case, it's a 1977 district court case that's not binding on this court, and that the preemption analysis is wrong. It's an outlier decision. It hasn't been cited once since, except by a District of New Jersey case to distinguish it. And, it appears to find, it says at one point that the state law is at cross purposes with the federal law, but that's not the standard for preemption analysis. and it contravenes both what the Supreme Court and the SJC had said at a later
Judge
time.
Aldrich's concurrence, he says it's an equal protection problem.
You know, the equal protection analysis is that distinctions can be drawn among classes of veteran as long as they're reasonably related to a legitimate state purpose. And here
Here it is because it's a difference between an armed force and a uniformed force. Could the state say, you know what, we don't like the Navy, so we're going to give benefits to everybody except people in the Navy? Could they do that?
I'd say it's harder to argue that that's a reasonable distinction if service members of the Navy have similar obligations and risks and mission as those of the other military
Well, you know
branches.
what, the Navy, they pulled out of such and such a port, so they're not in Massachusetts anymore, so we're just not going to, that rational and therefore okay? We're not going to, we'll give $2,000 a year to everybody but people who are in the Navy, because we don't like the way they, the way they peopled our state.
Because people.
Well, they pulled out of a port. I mean, this happens, right? Could the state do that?
I think that starts to look more as arbitrary. The distinction that the state has drawn here is one that's consistent with one drawn by many states with their own state-funded benefits.
Well, but it's inconsistent with the distinctions drawn by the federal government, right? Do you agree with that? He's correct that far, right? He gets
Yes.
benefits.
It is a different distinction than that drawn by the federal government. But to follow his, Commander DHANJI's argument, you start to almost run afoul of the 10th Amendment, which would require the states to basically implement the federal policy and commanding it to do so, which is a
Yeah, I
different.
understand that point.
I think Dr. DHANJI concedes in his brief, no benefits need to be provided at all. He just wants them.
That point I do understand, which is, if he's right, it doesn't mean that the state can be ordered to pay him. It just means that the state can't pay anybody because the thing is unconstitutional.
Right.
That actually occurred to me. All right. You have anything?
Justice Englander, I do not at the moment, thank you.
Judge Han? You have anything else you want to tell us?
I would just like to note that the department understands Commander DHANJI's plea that the Commonwealth recognize his contributions and that this is not to the legal merits, but there is a bill pending that
So I have
Governor
a question.
Healy.
Wasn't there a bill way back when and then it just died somewhere along
There
the way?
was. So the legislature has considered
Yeah.
expanding the definition of veteran. It hasn't done so in the past, but this administration, Governor Healy, recently proposed a bill in November called the HEROES Act. It's supported by the department. It would have the effect of expanding the universe of individuals who are eligible for the Section 6B annuity.
What your argument is, in this case, we don't get there because it's plain language, so
It's-
we don't.
it's plain language,
We don't
and-
peek under the covers, if you will, on that one.
And so yes, the department believes that the remedy should be through the legislative process, not through this appeal, and we'd ask that this court affirm.
Thank you.
Thank you.
Thanks to everybody. Thanks to all the courtroom personnel and support. Appreciate it. We are concluded, and we will stand in recess.